really, this is a legally binding contract, right?
Well, it's enforceable. Really, at the end of the day, it's the accountability document for your association.
Yeah.
What is the association responsible for? What do they owe you?
Yes.
And it sets forth that.
Yeah.
Or it should, right? I mean, some CC&Rs are imperfect, and we can get into that.
Yeah.
But at the end of the day, yes, it does tell you, certain specifications regarding what does the association expect of the homeowner. But conversely, what can the homeowner expect and demand and enforce against an association?
And I think that's where so many homeowners don't understand.
Correct. I'm Luke Carlson, and for almost 2 decades, my law firm, L.S. Carlson Law, has been at the forefront of defending homeowners against overreaching HOAs. We're not just leading the charge, we've created the go-to playbook on how to fight back effectively. Join us as we delve into the world of HOA disputes, sharing insights from our extensive experience and landmark victories. Throughout this podcast, we'll bring you in-depth interviews, demystify complex legal principles, and provide practical tips to safeguard your rights. While the information provided shouldn't be taken as legal advice, our aim is to empower you with the knowledge, strategies, and real-life success stories needed to navigate and overcome the challenges posed by overreaching HOAs. Hi, Luke Carlson of Bad HOA. Welcome back to our podcast. Marty, welcome.
Hey, thanks for having me. It's good to be back.
Thanks for being here, as always.
Yeah, thank you.
Special announcement. I guess we'll just lead with this, and we've been kind of teasing this in some sense.
Yes. There is a new piece of equipment on, on the desk here that's very sharp. So no, it's not a weapon.
No, not a weapon.
It could be used as one, but
it could be.
It's definitely not a weapon.
Looks like a spear. Yeah. So as you know, and as we were very fortunate, blessed, honored, really, to be identified by IMA as the #1 legal podcast of 2025.
Yeah. It kind of blows me away to when we first started this podcast, single camera on an iPhone, and just right to you. And then we brought in Jenny, and like the evolution of this. And I hear it time and time again when I walk through the halls with some of the consulting attorneys. They always bring up that some of the people that come in, a lot of them reference the podcast.
Well, that's
awesome.
As we engineered it, we thought about it to begin with. The purpose of it, why have a podcast, was obviously to empower homeowners, put a light on this. Put a light on this issue, which historically was very fringe. It was sort of whispered about how bad someone's HOA is. Yeah. But to take this podcast and bring it into the mainstream.
Yeah, some of those earliest podcasts that we did were the reaction videos to like the CNBC story or the John Oliver video, which was really starting to put a light on this. And so many people, it was just complaints about the HOA.
Right.
But being in this space for so long, what was the solution? It was like, this is why they're so bad, and this is what they've done.
Well, that was the issue, right? It was always, this is the problem, this is the problem.
Yeah.
And we wanted to really bring a solution-focused platform and educational series that had homeowners walking away saying, hey, I really understand my rights. This is how I'm going to tackle it. And really give them tactical and very practical know-how about how to deal with a really bad HOA. And I'm just thrilled with IMA. Now, IMA it's an honor because IMA is made up of individuals who are really the thought leaders, industry leaders. They're making huge change. And if people haven't seen IMA, look them up. Tremendous organization or association. And it is the creme de la creme. Yeah. I mean, these are the individuals who are actually moving and shaping the world. And it's honestly just a huge honor.
It's wild. It's like we never did this, for the award. But how cool is it that you go out just trying to be a resource to people, and it caught fire to some degree, and it's caught the eye of some people, which is really really rewarding. I bet the ultimate reward is when you hear people solve their problems.
Right.
Like, this is great, cool. But the ultimate award is that when people solve their problems 100%. Without needing an attorney. So that's really cool.
Well, special thanks to IMA, C&R. Thank you guys so much for this award, and we couldn't be more thrilled.
Yeah.
So, all right, now solving problems.
The reason that we do this in the first place.
Yes. All right, we got a good topic, and this one, we were talking about before the show, this is really a revisit of some of the earlier series that we did, and really just trying to kind of re-angle, refocus, and sort of provide additional information. And a lot of it's from feedback we've heard as well.
Well, so much of this has been an evolution, right? You get into something and you realize that can be, systematized, if you will, right? It could like the strike method or some of the homeowner empowerment things. There's frameworks of which that were developed that now that can be put into that framework, which is really cool. So going back over this, kind of having been in this for, a couple of years at this point, and revisiting this with a new lens, and that feedback I think is really helpful. Hopefully helpful for the people on the other side of this.
Well, we hope so. That's the goal. And why don't we jump right in?
Yeah. So we are jumping back into the dispute type of CC&R violations. And we've mentioned this before, that anyone that's actually watched this podcast, so much has, the CC&Rs, people think that it really restricts the homeowner on what they can't do,
right?
Or can and can't do. But most people think of that they can't do.
Well, to your point, it's almost two things. One, it's a document that sits in a desk collecting dust.
Yeah.
And the other assumption baked in is, well, even if I go into it, it's a rule book built against me.
Yeah, everyone. Right. It's like fences and paint and paint on my house,
right?
And landscape. That's like, this is what you can't do,
right? And if anyone's like almost done with this podcast, had a short amount of time to listen to it, the primary takeaway is that's wrong.
Yeah.
And it is a very powerful tool for a homeowner.
Yeah.
And we'll get into that. But if you have one takeaway, that is the takeaway.
Yeah. Listen, this also defines what if the HOAs are breaking the rules.
Right.
Right. Because it's really, this is a legally binding contract, right?
Well, it's enforceable, and it's really, at the end of the day, it's the accountability document for your association.
Yeah.
What is the association responsible for? What do they owe you?
Yes.
And it sets forth that.
Yeah.
Or it should, right? Some CC&Rs are imperfect, and we can get into that.
Yeah.
But at the end of the day, yes, it does tell you, certain specifications regarding what does the association expect of the homeowner. But conversely, what can the homeowner expect and demand and enforce against an association?
And I think that's where so many homeowners don't understand.
Correct.
And so many, just being in this world now, so many disputes arise from the HOA not abiding to their side of the contract. They're not abiding by the CC&Rs that are put forth.
Correct. All right. So I think that was a great intro to the CC&Rs themselves, the power source. So where do you want to start?
Okay, I think it's really important to define, because there's three components when it comes to HOA governance that a homeowner may or may not understand, right? And those three components are the CC&Rs themselves, the bylaws, and the rules.
Yep.
Right? So three primary components. So let's go through each one of those. So CC&Rs.
Yeah, the way I like to look at CC&Rs is it's sort of that overarching set of rules and responsibilities in which the association, or in which the homeowner can look at it as, hey, this is the association's obligations to the community.
Yeah.
Right. So it does very practical things. It talks about the common area, right? Maintenance requirements, all of these different restrictions and obligations. And it's in a very real way, a very broad overview of how the association really should operate.
Yeah.
And so,
and that's a legally binding document that's recorded with the county, or
correct. Yeah, it's recorded. It should be recorded. Okay. I always have to put caveats on the things. But yes, they should be recorded, and they're enforceable.
Yeah,
that's probably the best way to say it.
So like any other business contract, correct. I think that's where people get tripped up too.
Correct.
Is just like any other contract, this is a contract in the way it functions.
Correct.
Yeah,
you can enforce it against an association when they violate it. Right.
Yeah.
And so
but the inverse is also true. They can enforce it against you. Right.
Correct.
If you're not following your end of the bargain.
Now, what's interesting about that is you get into procedural issues too. And, we've seen it where, they've tried to enforce the CC&Rs against a homeowner, and then you just dust off the CC&Rs and look, and there's no provision that they're identifying as a violation, right? So you have to be very careful. So even if you're on the receiving end of a CC&R violation notice, just double check. Make sure that language is actually in there. Because I've found over the last, more than a decade now, or quite some time, there are situations where the association is enforcing something that doesn't exist.
Yeah, that blows my mind.
Yeah, but that's why we have a show.
Yeah. Okay, let's define bylaws.
Okay, so bylaws, a good way of thinking of it is corporate governance. So we've said this before. What is a board? A board is a legal entity, meaning it's typically registered with the California Secretary of State, and so it exists as a corporation. It's typically nonprofit, but it's a legal entity. And so the bylaws really articulate what does that corporate governance look like as it's attached to the entity itself. So now you're talking about more procedural things like meetings, more of the technicality of the running and functioning of the entity itself, which is the association.
So would it define like the number of board members,
voting,
or
quorums,
okay,
all of that. And I say ticky-tacky stuff because again, it goes to how is the association as entity supposed to run itself?
Those are the rules that they've set forth for running the board.
Correct.
Okay.
How does voting work? How do the internal procedures work? How do how should minutes be kept? All of this stuff should be in the bylaws. So a good set of bylaws contains all of this. And again, when we talk about a board, you have board members that make it up, right?
Yep.
So, obviously the board members are part of the board, but normally when a homeowner is going after an association, they typically go after the association, which is the entity, and not necessarily the individual board members. Now, there are exceptions to that. There's situations where the board members, their misconduct is so bad, so egregious that there's individual liability.
So something like that would be
malice,
embezzlement?
Possibly malice, really malicious conduct, yes.
Okay.
But generally speaking, how we frame things, it's normally you're going after the board. And that's, again, the legal entity.
The entity.
Yes.
Okay. So let's talk about then rules. So that sits under the bylaws. What's the difference between rules and the CC&Rs?
Yeah, well, one thing, rules are not recorded. And as I see it, there's certain procedures and there's requirements to create rules. But rules are a little bit more adaptable to situations. So, for example, if something isn't working on the tennis court and the association through the procedures, right, say, you know what, we need to shut this thing down by 8 p.m. because it's too loud. Typically, that's contained in a rule. And they're a little bit more flexible, right? Because I think we're going to go into this. When you're tinkering with the CC&Rs, you're not really tinkering, you're amending, right? It's a procedure. There's requirements. It's a lot of heavy lifting.
Yeah, so that's almost thought of as like a constitution, if you will.
In some ways,
to amend it is a much greater deal.
It's a procedurally heavy lift to do that. Yeah, and it's obviously doable.
Sure,
but when it comes to rules, those are a little bit more flexible, if you will. Now they still have requirements, right? They still attach to certain procedures, but it's way different than when we look at the CC&Rs.
Okay, so pool hours, pickleball, all the parking, all those little all the little things, the ticky-tacky little things that might come up in
different than corporate governance,
yes,
which is also very ticky-tacky in some ways.
Yes.
But it's almost, you could see it almost as a catch-all to stuff that the CC&Rs never maybe even contemplated at the time, because the CC&Rs may have been established in 2010.
Yeah.
And 5 years later, tennis courts came out.
Or
right? They installed
pickleball courts come out.
Or maybe I should say pickleball.
Yeah,
I'm dating myself.
Yeah.
But pickleball courts come into play.
Yeah.
Okay, well, they need rules. They need certain regulation around that.
Yeah.
Typically, those will fall in the rules bucket.
Okay. So there is an authority hierarchy, right? And I think where some board members get tripped up is in this hierarchy as well. And then we'll go into this and about how it changes and everything. But we've got the law at the top. You want to go down the hierarchy?
Yeah. So when we talk about the law, we're actually talking about the law of the land. So you start with federal.
Yep.
And then you go to state.
Yep.
Then you go to local.
Yeah.
So that is going to trump anything that happens on the other side of that equation.
And we'll get into that as well. But to the extent that the CC&Rs are in conflict with the state, local, or federal law,
that's a good way to say it.
They're not enforceable.
Yeah, and we've talked about this before with drought-resistant plants.
Yeah.
Solar. There's so many things that have been, passed down from Sacramento, for example.
Yeah.
And if the CC&Rs are inconsistent or conflict with that, the state law is going to overrule.
Yeah. Okay. Then we've got after we have the law, we've got your CC&Rs are kind of the top threshold of the hierarchy, right?
Yep.
So you can't have a bylaw or a rule that's in violation of the CC&Rs. They can't just add a rule.
That's correct. So when you look at the CC&Rs, typically the CC&Rs and bylaws are pretty consistent because there's not much overlap.
Yeah.
Right. So bylaws carry great weight, as do the CC&Rs, right? And then normally where you do see conflict is where it comes to the rule set.
Yeah.
Because of their flexible nature, you sometimes get very bizarre results. You get boards that go rogue, draft a whole bunch of rules that are 100% inconsistent with the CC&Rs.
Yeah.
And then there's massive conflict there. But then they set out to enforce those rules, irrespective of the fact that the CC&Rs just don't allow for that.
Yeah, that's just good old board ignorance or them being drunk with their own power.
Yeah, and sometimes we've seen this where the rules have actually been used and weaponized against individual homeowners. So a homeowner is doing a specific activity, and the board doesn't like it, so they'll actually go out of their way to carve out rules to target the homeowner, and they think they're being slick about it, right? But they move so fast in this sort of absurdity, this absurd attack, that they don't even check with their own CC&Rs. And so that's a big problem, obviously, because there you have targeting, you have selective enforcement, but you also have the board being in violation of their own governance.
Yeah. Okay. Let's talk a little bit about the three areas, both CC&Rs, bylaws, and rules, on what can be changed and what can't. CC&Rs is the highest threshold if something needs to be changed in it, and often requires a supermajority of, depending on where you're at, in order to amend them.
Yeah, so that is highly regulated. There's a tremendous amount of procedure around it. If you look at Davis Sterling, it's 4270, if I'm not mistaken. Civil Code 4270.
Yeah.
And so the reason that is because it's such a fundamental document. It's recorded, and it really impacts all the homeowners in a very real way, that any sort of change or modification or altercation to it has to be done through procedure.
Yeah.
And through vote, through notice requirements. All of these things have to be done by, with precision. And if they're not, obviously there can be a legal challenge to that.
So the Davis Sterling here in California outlines how that is supposed to function. If you are to amend them, then it's outlined in the law.
Yeah, and typically it's also memorialized in the CC&Rs as well.
Okay.
Now, if there's a conflict between the two, you go to Davis Sterling.
Yeah.
Okay.
I think that's another big hang up, like where a board can say it's right here in the CC&Rs, and your argument is, it's the law. It makes this, this was drafted in the 80s.
Yeah. The stronger argument, obviously, is state law.
Yeah.
So,
okay, bylaws. To amend bylaws, you want to talk a little bit about that?
Yeah. Normally when we talk about the amendment of bylaws, you're going to find that directly either in the bylaws themselves, or possibly in the CC&Rs, or both.
Yeah.
The Davis Sterling Act speaks to it as well.
Yeah.
But again, there are regulation, there procedure. And if you're ever in a situation where the board is looking to amend bylaws, what you're really looking for is, are they following the proper procedure? Are the proper notice requirements out there?
Yeah.
Is the voting, has that been established? And really the issues that arise with amendments where you see a bad HOA, it always comes from notice. Typically, I shouldn't say always, but the vast majority is no one was notified of these changes.
That's interesting.
And they're trying to slip it under the radar. So that's a big issue, especially in California, where you get these rogue boards. They're trying to amend or do what they want with the CC&Rs, but they're not following the notice requirements.
That's interesting. But the same applies for rules too. Now they can change rules, right, with a board vote.
So those become a little bit more lackadaisical.
Yeah.
Right. And so just think of the rules as the more flexible set.
Yeah.
A little bit more user friendly.
Yeah.
And ultimately, if you look at why that is, it's likely because those rules don't have the drastic and dramatic impact that the CC&Rs do, or the bylaws.
Yes. But it's worth mentioning, at least here in California, in order to make those rule changes, they still have to follow the law.
100%.
I think that's where boards might get it wrong too, is just because you have the power to change the rules, still has the requirements, it still has a structure, it still has procedures that you must follow.
100%. They're just not as it's not as procedurally heavy in some ways.
Yeah,
is my point. But no, absolutely. I mean, listen, you have to understand it. If you're on the board, you have fiduciary obligations, you have statutory requirements, you have contractual obligations, you have so much governing what you do.
Yeah.
And so whatever you do, you better make sure that you're following it to the T.
Yeah. So let's talk about those rules real quick. There is a provision in the Dave Sterling that in order for it to become enforceable, the board has to give advance notice of a potential rule change,
which is typically, I believe, 28 days.
Okay.
Double check, but I think that's
then
right.
They must give time for a homeowner to comment.
Correct.
A vote at a board meeting, and then they have to send a notice after adoption.
Yeah.
So still, this is all about transparency. Right. It feels like so many of these issues arise from lack thereof.
Well, yeah, like I said, it's a rogue board hates transparency.
Yeah.
They hate when a light shines upon what they're doing.
Yeah.
And so if a homeowner understands that they just can't, pass things in the middle of the night, right? Now the homeowner has leverage on that situation.
Yeah.
So
if they don't follow those procedures, that rule can become unenforceable.
It might be void.
Might be void altogether.
Right? And so there's strong ground to attack.
Yeah. Okay. So let's just go through real quick how a HOA can break the rules, right?
In a lot of ways.
So there's... Okay, number one is ignoring the CC&Rs, which is skipping procedures or selective enforcement. Selective enforcement it's always funny because it seems like such a vendetta against somebody.
It typically is, right?
Yeah.
You have it. It's another way of saying it's just targeting.
Yeah.
And when you sort of look at these disputes, the typical algorithm or format is you have a bad actor on the board who dislikes one person or a group of people. And all of a sudden, all that power, right, is being channeled towards harassing or just making one person's life a living hell.
Yeah.
Or a group of people, right?
Yep.
And that could be from sort of cherry picking from the CC&Rs. Mm-hmm. Even though, everyone else is in violation of something, you're the only one being targeted. Mm-hmm. Right? Or it's making up CC&R rules that don't exist.
Yeah.
Like I said earlier.
Yeah. Okay, second would be acting outside their authority, treating rules like law, or just flat out making things up. Like, because so many people just, hey, I'm on the board, I'm the board president, I tell you what to do.
Correct.
Kind of a thing.
And they couldn't be more wrong, but it happens all the time.
Yeah.
And it happens because a lot of individuals, a lot of homeowners historically have just accepted that.
Yeah.
And they've said, oh, well, he or she, they are the board president. But
it doesn't mean that they can do whatever they want.
If anything, you have much more attack lines.
Oh, I mean, fair point.
Right?
Yeah, true.
So they're in the hot seat in a lot of ways.
Yeah.
So they just can't go rogue.
Yeah. Okay, ignoring the law, or trying to enforce outdated provisions. And then the examples that we kind of gave earlier were, particularly in California, so many laws have changed around solar.
Solar's a big one. ADU.
Yeah. And the landscaping.
Landscaping is also a massive one. And so, yeah, you get these board members who, and some of it, and we actually touched upon that in the book, they're just incompetent.
Yeah.
They just really don't understand what they've stepped into.
Yeah.
And that's no excuse, right? But sometimes they simply don't understand that, state law will trump CC&Rs, but they're so fixated on the CC&Rs, they don't understand that what they're enforcing is in violation of state law or federal law for that matter.
Yeah. I mean, you've said it before, ignorance is not a defense.
Correct. Even though sometimes they attempt to leverage that as a defense.
Yeah.
But the reality is, the law is the law.
Yeah.
So if you don't understand it, that's on you.
Yeah. I really like this one because I think it really bears us diving into it and just describing what it is. But violating fiduciary duty. Board members must act in the best interest of the community, enforce rules uniformly, and avoid favoritism. I just want you to explain in layman's terms what a fiduciary duty is, because I think that is really, really important. That I don't think most homeowners understand that when a board member decides to run for the board and get on the board, they have this elevated sense of responsibility.
Yeah. So to understand fiduciary duty, you have to understand standard of care.
Okay.
So, and the standard of care in its most simplistic form is like, what would a reasonable person do in that circumstance?
Okay.
So, for example, if you're, parking your car and you park it in front of a door, an emergency exit, and it causes a problem, that's likely negligence because you fell well below the standard of care. A reasonable person would not have parked in front of an emergency exit. Okay, that's a simple way of saying it, right? So when we talk about fiduciary, it's a heightened standard of care. It's not just an average standard of care. It's heightened in the sense of the board almost has to go above and beyond to some extent to ensure sort of, what is in the best interest of the community. There's a little bit of extra due diligence. It's extra care. It's a heightened standard. Lawyers have that to their clients.
Oh, sure.
It's not the basic standard of care. It's an elevated standard of care. It's heightened.
Would like doctors have a
doctors have it as well.
Yeah.
And so, at the end of the day, when they fall below the standard of care, which is just how the reasonable board member would act, it's not only a negligence, right? But it's also going to be a violation or a breach of their fiduciary. So it's a heightened role. And again, when you step in on a board seat, that's something you should understand very well, because you can't just mail it in. You can't just go rogue or shoot from the hip. This requires thought. It requires care. And why is there a fiduciary? Because your role is so important. You're overseeing millions of dollars likely in real estate assets. You're impacting people's lives. Sometimes, a handful of people, sometimes thousands of people.
I think that's one thing that I don't know if all board members really understand is, number one, fiduciary. Right. And number two is you are running a real estate organization.
A mini empire.
Yeah. In some ways. That has millions and millions and millions of dollars worth of assets that fall.
That's under your control.
Yeah.
And so the law expects you and demands that you apply a higher standard of care. And you treat it.
Is that something that when a dispute kind of bubbles up and you see a potential client coming through the door, is that something that you were arguing for against their breach?
Yeah, breach of fiduciary is very common.
Okay.
Because look, listen, if you're targeting, that's a problem unto itself, but it's also a breach of fiduciary.
Got it.
If you're, failing to maintain common areas and it's bringing down the fair market value of the community. Yeah. Well, yeah, that's going to be negligence, most likely, but it's also going to be a breach of fiduciary.
Yeah.
So it almost goes hand in hand.
Interesting. So you learn something new every time. Okay. We already touched upon ignorance is not a defense, but also rewriting the contract. So changing the rules, we change the rules. Yeah. But done without a vote or an amendment.
Yeah. So essentially it's just void and, it can be attacked, but it won't stop a bad HOA from trying to enforce.
Yeah.
That's where you as the homeowner have to, sort of be proactive.
Sure.
Challenge it. Just because you got a violation notice doesn't mean you should just wave the white flag. Look at your CC&Rs, double check state law. I mean, yes, it does require some effort on your part, but there's value in that.
Yeah. And likely if there's a good chance if you are having an issue, some of your neighbors might be also having the same issue. Which is a good segue to shifting the leverage,
yes,
right?
I actually was thinking the same thing.
Okay.
On strike.
Yes. So if the HOA is breaking the contract, ignoring procedures, enforcing invalid rules, then we have our acronym, strike, right? So let's go through the acronym. S is for stay calm. So in this context, we've said it multiple times, bears repeating. Remove the emotion from the situation, which I know can be extremely difficult considering this is your home and emotions run high and your neighbors can just flat out irritate you.
Well, yeah. I mean, I fully understand the emotional toll very well, maybe too well, of what these situations have on the homeowner.
Yeah.
Right. And if you have a scenario where the president is targeting you.
Yep.
You know that it's some BS CC&R provision that doesn't exist. Your natural reaction is most likely going to be go over the top against the association president, right?
Yeah.
Rightfully so, but it doesn't help you. It doesn't have that ROI.
Yeah.
So again, S for stay calm is just worth its weight in gold in terms of value, because you want to present yourself always as the calm, rational one.
Yeah.
Even though instinctually you want to rip the person's head off. I mean, let's be honest.
Rethink the late night emails. If you have
Yes.
a nasty email, then wait to send it the next morning.
Yeah, a good
with
sign.
fresh-
If your email is in all caps, take a breather. Maybe even run it through an AI system before you send it.
Yeah.
There's a lot of technology that can help you take that emotion out of it if you don't want to do it yourself.
Tons of GIFs and emoji or whatever.
Right.
Okay. My favorite part of this, though, is assume that those correspondence, a judge, a mediator, or attorney is going to read it.
100%.
Yeah, I love
it's
that
evidence.
one.
It becomes evidence one.
Yeah.
So why don't you stack the deck in your favor?
Yeah.
So
yeah, I love that. Okay. T for strike, track everything. The famous line is, if it's not in writing, it didn't happen.
correct.
Yep.
So this goes to really keeping an organized file on the dispute.
Yep.
And also verifying. So when I talk about track everything, so HOA comes in, you violated section 3.217. All right, well, let's look up that section.
Mm.
And then pull that section, especially if it's an error, right?
Mm.
And then catalog that. That becomes part of the war chest behind the scenes.
Mm.
So track everything and put everything in writing. So, for example, if they are dead wrong, if they incorrectly cited you for a provision that doesn't exist, or just didn't articulate it correctly, or didn't understand its meaning, or they misinterpreted it, maybe intentionally, even if you bring it up at the board verbally, you have to put it in writing.
Mm.
Lay
Yeah.
out your position in writing. Again, sort of incorporate the S, stay calm when doing so,
Yep.
but it should be memorialized in writing.
So you have a verbal conversation with a board member. They say one thing, go back, write the email back and say, confirming our conversation. This is what we have agreed to, or we talked about. If this
Right.
is wrong, please respond back with your side of the story.
Well, yeah. So that last sentence I love, because it's very helpful from an attorney's perspective, but it's memorialize it.
Yep.
This is what happened. Last sentence, if anything is incorrect or inaccurate, please respond to this email in writing, or, please respond to this email.
Yes.
Please respond in writing. The point is, you're putting a burden on them to push back. And if they don't, well, then, it starts to look like your version of the narrative is the actual correct one.
narrative.
Yeah.
Yeah. Okay. Let's go to R, record and organize evidence. So we talked about this a little bit, but build a clear timeline of evidence. This goes back to like the homeowner empowerment kit, which shameless plug is on our subreddit. You can download it. It helps organize all the evidence for you.
Organization is everything, especially let's say at some point you have to hire an advocate. You have to go the lawyer route.
Yeah.
It's so helpful for an attorney when you're partnering, because at the end of the day, you really are partnering with the lawyer.
Yes.
If you have that evidence laid out, if you have that timeline, if you have the key documents, it makes everything just so much more user-friendly.
Well, I think the other thing that people fail to realize too, there's an economic reason to do that.
Yep.
If you do get an attorney, wouldn't you rather have the attorney have everything laid out versus them having to sift through it? There's a lot more hours of on just sifting
Correct.
that you can solve ahead of time.
And sort of to go to the attorney side of things, if you get 5 banker boxes of information as a lawyer, I mean, talk about fiduciary. Your fiduciary is to go through every box that was given to you. Because you can't be that lawyer who is like, oh, I missed that one most critical piece of paper. Now it's a needle in a haystack, and I get that. But a good lawyer goes through every document you provide. And they're not just going to take 3 boxes out of the 5. That's good enough. Arguably, that's in violation of your own fiduciary, the attorney's fiduciary to the client.
Yeah.
So the better organized, the more efficient the attorney will be. And yes, that will save you money.
Yeah.
So
I love that. Build a clear timeline of events. take timestamped photos, document similar violations ignored by the HOA, favoritism or selective enforcement, or procedural failures like no notice, no hearing, no vote. This is where you're building a case showing that the HOA is not enforcing rules uniformly. I love that. All right. I in strike is invest in knowledge. We talked about a lot about this, but read your CC&Rs carefully. I mean, they say that you're in violation of them. You should go back and look at what they said that you're in violation of.
Yeah. Again, they're not just some passive, irrelevant documents.
Yes.
They're important, they're critical, and they will have massive import on how you push the case forward or what decision you make regarding the dispute.
Yeah.
So yeah, invest. Again, it takes time, but it's time well spent.
Yeah. And then understand, we talked about the hierarchy of authority. There might be a situation where new state law, new local law for drought tolerant plants or something now trumps that CC&R. So if you're trying to if you know that it does, have that ready to go.
Right.
Have a response ready and say, this law passed, it's passed as of X, and this is post these CC&Rs, therefore your fine is no longer relevant.
Yeah. And again, we said it's an investment, but it's worth it at the end of the day.
Yep. Okay, I like the next one for K. Keep it precise. I always like this specifically because elevating your language can really show in that lens that you really mean business and you're sophisticated and you shouldn't be messed with.
100%. I mean, language is so powerful, and for you to go in and say, this is BS, you guys are a dumpster fire, this is a nightmare. I mean, you're conveying emotion, I think, very well, and people will understand how frustrated you are, and I think that will be received. However, it won't be received with precision. You have a homeowner who comes in and says, hey, this is violating the Davis-Sterling Act, specifically this part of the Davis-Sterling Act.
Yes.
Or you guys, the HOA, are in violation of the CC&Rs and specifically these sections of the CC&Rs.
Yes.
That's powerful.
Yep.
And eventually, most of the time there's a lawyer on the other side of that table, or it gets back to the lawyer, and that lawyer for the association starts to hear that a homeowner is citing provisions of the CC&R, citing provisions of the Davis-Sterling Act, is citing evidence that was said before, inconsistencies, is claiming, breach of fiduciary, violation of CC&Rs, violation of state law. That gets on especially an attorney's radar pretty quickly.
Well, I mean, if there is a bad board member and they think they can just, play you, this is the first bit of evidence that might be like, maybe I shouldn't mess with them. This might be the flag that's waving like, maybe you shouldn't be messing with this person because they're clearly on a level that I shouldn't mess with, right?
And maybe the board themselves aren't on that level.
Correct.
Right? You have a bunch of board members who are, Googling fiduciary in real time. So
that's so scary.
Well, it needs, essentially what you're doing is you're telegraphing that you could be a very real legal threat. Yeah. And you understand your rights, and that normally is received a lot better than a homeowner just yelling and screaming that the HOA is a dumpster fire. Yeah.
So we have the example of, don't say you're violating the rules. Say you're not complying with CC&R provision 3.71 on page 9 and the required enforcement procedures.
That's a huge difference. That becomes surgical. That's a surgical strike at that point.
Yeah. Cite sections, use exact language, stay factual, not emotional. That goes back to our first point. Okay. Yep. E, the last one. Escalate only if necessary. I think this is a great one because there's no reason to. Sometimes you don't need a scorched earth on just a quick surgical strike could have fixed.
Yeah, and I suppose somewhat of the irony of the show is we're trying to set homeowners up in the best way possible so they actually don't need to use a lawyer. Yeah, as I see it, if you can avoid a lawyer, that is a huge win for the homeowner. Yeah. So your process of being surgical, responding in a way that's clinical, trying to work it out first with the board, really is meant to offset a need for an advocate or a lawyer. Yeah. And so, one of the methods of doing so before, I guess you go nuclear option is, the IDR process, informal dispute resolution.
Yep.
Which we've talked about on the show. And this is, we talk about it in a California context.
Yep.
But IDR becomes such a powerful method to at least start the conversation with the board.
Yeah. And just a quick primer. If no one's ever heard of IDR, there's a provision in the Davis-Sterling Act. And the whole purpose of this was to try to get things solved without legal, without
court. And, at the end of the day, just to make it simple, just to, put it in a nutshell, it's a demand from the homeowner to the board, typically through email.
Yep.
Demanding IDR or informal dispute resolution.
Yep.
And then in that email, you outline the dispute.
Yeah.
Here are my issues with the board. Here's where I think that there's a violation specifically. And that's where you kind of go to the precision. I'd like to sit down with the board, meet with them. Please provide some times.
And the board is supposed to, according to the law, respond to that request.
Yes. In good faith. Again, it's a safe harbor provision, if you will, to get these disputes resolved before they ratchet up to a full-blown legal dispute.
And then the whole purpose is to try to solve this without lawyers,
yes.
which I think is important.
Now, sometimes that's not possible, and I know why. You have the tyrant on the board. You have just, to use an emotional language, you have maniacs on the board. Okay, and I wouldn't encourage a homeowner to subject themselves to a meeting with a bunch of maniacs.
Yeah,
right. I just wouldn't.
Yeah.
Okay? But to the extent that it might be a miscommunication or you think that there are a handful of reasonable people on the board, IDR is a great way to start.
Yeah.
At least start the conversation.
Well, I think, too, it also shows, again, assuming that everything gets in front of a judge or mediator or attorney, you tried everything to resolve this. And that just reflects well on you. Like, I tried to initiate IDR, they ignored me.
Right.
I tried to do this, they did this. There's always something. You're building a case for yourself by even attempting it.
Yeah, a great piece of evidence, too, is where we have a homeowner who reaches out to the board very reasonably, diplomatically, saying, I'd love to go to IDR. And the board either rejects it or just ignores them. I mean, who's reasonable in that sense, right?
Exactly. Okay, so let's talk about... kind of starting on our wind down of this thing, let's talk about the red flags on when to potentially bring in legal counsel.
Okay.
Number one, the board is ignoring the law. That might be a good trigger.
That's a big red flag, because if they're just flat out saying that state law doesn't apply, which I've seen emails before along those lines, where it's just a blatant disregard for the law, maybe you start talking to an advocate.
Yeah, it just shows that they're so unreasonable or so incompetent.
Or entrenched in their position.
Yeah, that it might...
You may need some additional firepower at that point.
Yep. Okay, let's do the next one. Number two, they change rules without following the process. They don't give the 28-day notice, no member comment, no board vote. They are just flat out doing what they want without procedures.
At that point, I mean, that's so rogue and so egregious. I mean, I don't know if a board who's willing to go that far in violating the rules, et cetera, that they'd be willing to compromise at an IDR. You see what I'm saying?
Yeah. Okay. They ignore the CC&Rs, skipping enforcement procedures, no hearings, no required steps. Breach of the governing documents.
Yeah. Again, we go to the egregious nature of it. Now, that does presuppose that you're not dealing with a number of incompetent board members.
Sure.
I would almost take all of this with the asterisk, or put an asterisk next to all of this, where if you don't know, in other words, if you don't know whether the board is just ignorant or they're tyrannical, IDR might be the first step to kind of suss that out. But if you know unequivocally this is just a tyrant doing what they want to do, okay, then maybe it's time to lawyer up. But if it's, hey, these individuals are just incompetent,
they
just
don't
understand. IDR could be a good educational session where you just open their eyes, like, hey, this is fiduciary, this is CC&Rs, this is the hierarchy of how laws work.
Yeah.
So just keep that in mind, or the listener should keep that in mind when understanding our position on this.
Yes. Okay. Clear selective enforcement or favoritism.
Well, that typically is not ignorance. That's malice. That's intent. Right? So they're maliciously going after you, and that's a huge red flag.
Yeah, it's unlikely they're going to respond to you if they're already being that malicious in the first place. Okay. They stop communicating or start gaslighting you.
Yeah, this one is unfortunately all too common, where you have a very reasonable homeowner reaching out, trying to be solution focused, and either the HOA just shuts them down, doesn't respond, or I like gaslighting because I see it all the time. They try a bad association does a good job making the homeowner feel like the crazy person. And that's such a telltale sign that you have a really bad HOA. When you feel like you're the crazy person, even though you're being 100% reasonable, you've presented your evidence, you're reading the CC&Rs, and it's crystal clear, yet they make you feel like you're way off the deep end or off the reservation, that's a good sign that you may want to lawyer up.
Some high school level of relationship drama right there.
It can be, yeah. Very much so.
Okay. This is a good one. The next two I think are super important. You receive a letter from the HOA's attorney.
Yep. If they have a lawyer, I would recommend having a lawyer.
Because in some cases, we have to remember it's the HOA's lawyer.
Yeah.
They are operating their advocate.
Well, anything you can and say will be used against you.
Yes. Yeah, and they might try to twist you into saying something that you might not have the proper context or whatever.
Yeah. No, whatever. Yeah, like I said, whatever you say can and will be used against you.
Yeah.
That's the quote, and that's true because you do have good association lawyers, and I recognize that. And typically we don't come across them quite often because we don't have disputes with them. But quite often you have these association lawyers who have consumed the Kool-Aid, or they've bought into the bad HOA's behavior. And so, there is often times where the association will actually weaponize an association attorney and say, hey, go after this person. And the association attorney will say, yes, I will. So just be careful when it comes to that. And that's why I say, if you see that, you may want to lawyer up.
Because it's possible they could have hired one of their cronies as the attorney, and they might be paying them a boatload.
I've seen that before.
Yeah.
Yeah. So there's a lot of problems there. So just be on high guard or high alert, especially when you get hit with a lawyer letter.
Okay. And the last, threats to your property or finances. Threats of foreclosure, fines are escalating aggressively, threats of liens might not be just theoretical. It could be a real risk at this point.
You're in the danger zone there. And then also I would say any threat to your actual property by way of property damage. If you have a common area that's flooding and they're not listening, or if you have a roof in a state of disrepair and your unit continuously gets flooded, okay, that's very problematic.
Yeah.
So that's a good point where you may say, hey, maybe I at least consult with a lawyer.
Yeah.
So,
well, that's that. I think that the big takeaway is CC&Rs are extremely powerful. They're a powerful tool for the homeowner. They hold a lot of weight, and just because you are restricted and tells you what you think you can and can't do, it's so often that so many of these disputes arise because the HOA doesn't fill their half of the bargain, which is they must also abide by the CC&Rs.
Very well said. That was a nice bow on top of this episode. So thank you, Marty. And
thank you.
And again, thank you, IMA, for this beautiful award.
Yeah, this is great.
Absolutely honored. And thank all of you for watching. If you like the show, subscribe, leave a comment. Also, feel free to go to our Bad HOA subreddit, leave comments, interact with the community. And again, it's all about empowerment. And
we have done episodes based on people's feedback there.
Oh, 100%.
If they say, hey, I really need some clarity on this type of whatever, or whatever it is, we've taken multiple episodes from suggestions from comments there. So leave them there. We definitely look at them.
Yep. It's worth your time, and we thank you for doing so. And the show just keeps getting better and better.
Yeah. Hopefully another one in the future.
Yes. All right, guys. Thank you, and we'll see you next time.